Thank you for tuning in to my video today. I've got a lot of substantive videos on the internet where I talk to you about wills and trusts and probate. But I recognize, because of a case we're working on right now, that I have fallen short in sharing with you when you should review your estate plan and give serious considerations to changing it. So let me give you some examples and some ideas on that subject this morning. If your child or other beneficiary marries, and if you have a reasonable thought that perhaps it's not the best choice, then you should probably consider reviewing your estate plan. There is something about troubled relationships that seem to bring out the worst in both of the parties involved. So even if your son's new wife might generally be a decent human being, if the marriage begins to go south, she might be tempted to behave in less than an honorable way. With some regularity, we see spouses who are in a troubled relationship coercing each other to do things that might not be wise. So if your son were to inherit your estate, his spouse might say things like, if you loved me, you'd be putting that in our joint bank account. And as you probably know, when he does that, it becomes marital property subject to division by a divorce court. On a similar, but not the same issue, if your child were to start a new business, you should keep in mind that most new businesses are going to fail. And often, when the business fails, creditors come in and take everything that the owner had. If you've made a provision in your will or trust that gives everything outright to your child and they are going through a business failure, they're going to lose that inheritance as part of the bargain. But if you come see us with that situation in mind, we can make sure that your child gets a benefit from the inheritance, but it's not available to be taken by creditors. Some of us have children or other relatives who are always on the cusp of financial failure. Some of them have filed bankruptcy before. Some of them appear to be always on the edge of bankruptcy, and we don't know quite how they managed to stay out of the bankruptcy court. And we know that they're going to end up there someday, more likely than not. If you don't plan with those situations in mind, the bankruptcy trustee may come in and take the inheritance and apply it to the Visa, MasterCard, American Express, and other bills. If your beneficiary spouse gets a terrible diagnosis, you probably need to reconsider your own estate plan. Your child who inherits money outright is still on the hook for his or her spouse's medical bills in Oklahoma. I have seen creditors file suit more than once against the surviving spouse uh, whose deceased spouse left behind medical bills. The state law gives them that option. Now, I mention it because we can plan around it such that that inheritance won't be available to the creditors. But you have to plan in advance. If you personally get a bad diagnosis, that seems to be one of the most difficult times for people to update their estate plan, and yet it's the most urgent time. it appears that people see uh, estate planning as giving up or a lack of confidence, lack of faith in their God, or things like that. And they choose, maybe not consciously, maybe consciously, not to take care of their estate planning. I will tell you that that situation leaves them open to an outcome that is far less beneficial to their family than it could have been. I've been in the hospital where families have known for years that mom or dad had a terrible diagnosis. And at the last minute, long after a reasonable time has come and gone, they want to do estate planning. Don't be that person. That's wasteful. That's foolish. At best, it's terribly unwise. Likewise, if your own spouse gets a terrible diagnosis, it's time to do some asset protection planning. Now, it would be better if you would do the planning long before the diagnosis. But since we're talking about maintenance of an estate plan, I'm telling you that even if you already have an estate plan of some sort in place, the instant you know or seriously suspect that something bad is going on with your spouse's health, get in and do some estate planning review and consider making some updates. Some of you are likely to have an incapacitated family member or beneficiary that's drawing some Social Security. Maybe Medicaid is paying for a nursing home. Maybe Medicaid is just sending someone to their house to help them stay at home. In such situations, you need to make sure that your estate plan does not gift money to them outright. You could cause them to lose their Medicaid benefits, which could cause them to be forced into a nursing home and, and force your money to be spent on that nursing home just because you made an unwise estate planning decision. If your children or grandchildren are constantly fussing and feuding, or more optimistically, they just don't get along really well, consider the possibility that they and you and your estate will be far better off if you will select an outsider as the trustee or executor. If you use an attorney, an accountant, or a trust company, you're going to drastically increase the chances that your wishes will be followed precisely and that your family will get exactly what you set out for them to get. Where the executor is feuding with her sister and nobody trusts the executor, the outcomes are going to be expensive and wasteful. So there are some things you can do. If you have an incapacitated family member, consider funding a special needs trust for their benefit. A special needs trust funded with your money, not their money, will not have to be paid over to Medicaid if they die prematurely. Next, consider using professionals as your trustees and executors. They're going to be free of outside pressure, or at least they're going to feel free to ignore the outside pressure, and they're going to follow the provisions in your will and trust. Lastly, and perhaps most importantly, consider giving your gifts to your beneficiaries in the form of separate share trust. Those funds can be readily available to help your beneficiary, even if the beneficiary is in the midst of a lawsuit, a divorce, has a terrible medical diagnosis, or such. So there's no single special answer that tells you when to review your estate plan. I would suggest that at least every couple of years you should look at it. And I would also suggest to you that anytime something serious happens in the family, such as a diagnosis, a change in marital status, and the like, it's time to review your estate plan. Thanks for sharing this time with me. And if you'd like some more thoughts on your particular facts, I hope you'll give me a call. The office number is 405-733-8686. Currently, we have offices in Midwest City and in Edmond, Oklahoma.